Good morning, everybody, and welcome to this next episode in Taking the Helm, where we discuss chairing boards with Professor Mervyn King. Now, Prof King has just come back, literally just landed home from London, where he was awarded the Future Finance Award, Lifetime Achievement Award. I'll pop it up. I'll share my screen and pop it up for you all to see. In the meantime, if people who haven't been on our webinars before, please have a look at the chat function and let us know where you're from. And any questions you might have, please pop them in the Q&A function. I'm just going to share my screen, and you can see the award that Prof King then it was awarded this week. So Lifetime Achievement Award. And certainly Prof King hasn't only impacted accountants and auditors around the world, and with their thinking and as you say, finance for the future, it's also in terms of the governance of organizations. Now, as you know, that all of this experience doesn't only come with the lovely lessons of what has worked, it also comes with those things that haven't worked. So today I'd like to discuss with Prof King where boards haven't worked. But let's just start off by asking Prof King, what do you see as a dysfunctional board or a board operating with discord?
Well, Kerry, it's you posing that question to someone who wouldn't have allowed a board to become discordant. So I'm going to answer your question as if I've just become a new chairman. And it's certainly not a board that I've chaired before, because I would have dealt with the matter. So let's assume I'm been appointed as new chairman of this company. And let's take it to be a major company listed in London, from which I've just landed a couple of hours ago. I go to my first board meeting, and it's apparent there's discordance, and the two people talking, at odds with each other. So first of all, I pull them up and say, please talk through me. And I think you know already how I achieve that as meetings go on. But I would have looked at the company's MOI before I accepted the appointment as a director. And certainly, or articles of association, it's called in some jurisdictions. If it didn't have a clause in there that the board has the power to remove a director, I don't think I would have taken the appointment, because otherwise you've got to go through an extraordinary general meeting, and there may be some linkage between some major shareholder and this person is causing the discordance. And you're not going to get rid of him anyway. So it's very important, as I've advised many companies around the world, to write into their articles or memorandum of incorporation, as it's known here in South Africa, that the board has the power to remove a director. So the first thing, as the new chairman, I would approach with the power to remove a director. That's the first thing. The second thing is, if I note this discordance and this discordant behavior between Mr. X and Mr. Y, I would talk to them outside the boardroom and say to them, I am a new chair, and I don't know if you've ever gone offline and found out if the board as a collective actually has a unified mind in making business judgment calls. Or you're all thinking of one thing and another person's thinking of another purpose and everything. And in those situations, you would usually find they would say, no, Chair, we haven't. First thing I would do is go offline, and I would tell them, let's see if we are a unified board. What is the purpose of the business of this company? And to really get them to understand what the purpose is and to agree the purpose. Well, how many days before the meeting do you get your pack? Because you should get it at least a week before. You all know your duties of good faith, care, skill, and diligence, but diligence means really doing your homework. And please understand that I will test you as we go through the meetings to see whether you have done your homework, and more particularly, if you understand what's going on around you. Now, I have been inducted by the company secretary, and I can see how you make your widgets. Was absolutely fascinated by the factory and everything. And so anyway, we've got a board meeting in a month's time, and there's a very important issue about buying a new piece of plant to make the widget at a different angle or whatever it is. Let's have this offsite meeting, and I will go through them. What are the KPIs that you really think of? Get agreement on that. What are the key risk indicators? How do you believe we should achieve our purpose? And get the board to be thinking as a collective, singing from the same hymn sheet, because otherwise you do get discord. Right, so in a month's time, I have a meeting, and it's apparent that there are two members of the board that just don't see eye to eye. And they start talking, at the end of the table, across the table, and being disruptive in the meeting. I, of course, will pull them up and say, you speak through me. And the purpose of that is that you don't have this chat going across the table. And I will then come to that board issue to make widgets now at an angle and the 30-page management report. And I would have phoned you, Carolynn, and say, you remember that board? I said, Carolynn, have you read your papers? Yes, Mervyn, I have. And I would say to you, well, I want you to go to it in greater detail, because when we get to that issue, I'm going to call on you to talk about it. So just start the discussion at a more informed level than just the management report. And then go around the table and talk about it for, say, 45 minutes. And then I would say, I think the board is inclining to make a decision X. Do you agree? Yes, Chair, yes, Chair, yes, Chair, yes, Chair. Then I will just pick on one of the discordant persons, and I will say to him or her, will you please explain to me in great detail why you voted in favor of this? Yes. Now, if that person has not been diligent, has not understood that management report, has not understood the more information that Carolynn has put before the board through her research, he obviously is not carrying out his duty of diligence. And not to understand and to make a decision is a fraud on the company, because as a director, you are a guardian of the company's assets and its business affairs, and you should in good faith be doing something in the long-term best interest of the health of the company. And so I would ask that person to explain to me why they voted yes. Now, if they haven't understood all this, they'll sit there with 2 rows of teeth and with great embarrassment. And certainly I can tell you the level of homework starts improving in the board. And people don't just talk across the table. They really do talk through me, and I control the meeting. But if the discordance continues, I would go offline with these 2 persons and say, X, why are you disagreeing with Y all the time about this A issue? So X will say this, that, and the other thing. And I said, why? What about you? And I would ask X, do you know who nominated you to be a director? I think so. And so ask the other one, do you know who nominated you? No. And I will check that with the nomination chair of the nominations committee. And I will go back to the shareholder, major shareholder who voted for these people. Why did you vote these people to be on the board? And I would then start a process of conciliation between the two people. Now, conciliation is a process different from mediation. Mediation is you have the meeting between the two discordants, and you have the meeting, and you let discordant A say his piece, and you have discordant B say her piece. And you listen to both and try and get them to resolve it and come to a resolution on this issue that they don't see eye to eye on. Conciliation is you do that, but you, the conciliator, actually suggest to them what the resolution should be. And remind them that I've given this much consideration, and I think that's the resolution. And that fits in beautifully with the unified collective mind of the board. Don't you agree? And please remember, if you don't come to an agreement, I am going to exercise my powers to remove one or the other, or maybe both of you, from the board. But I cannot hold board meetings with this discordance going on. And I find, Carrie, I have had discordance on boards, but it's a board that I said, that's right, let's approach it, that it's not a board that I, have been, I just arrived at, not a board I've been sitting on, because it wouldn't happen. But that conciliation process, it's quite interesting. In the end, the suggestion you make, they usually both start agreeing to it, So you sort of take this, my thinking is superior to yours, sort of away from the both, and you give so you actually suggest the answer and they come to an agreement, and then you carry on. But if, of course, the discordance continues, then you exercise your power at the next board meeting, and you talk to major shareholders to say you're exercising your power under the Memorandum of Incorporation or the Articles of Association, and you're going to remove it, and the shareholders, of course, can react to it or not. Now, if you don't have that right in your MOI to hold an extraordinary general meeting in a listed company, it's expensive. And of course, you don't know the outcome, because you don't know what the relationship is between the XYZ shareholders and this one discordant director. So that's, Carrie, how I have handled discordant issues through a process of conciliation, not mediation. That I actually hear both of them, and I think about it, and I suggest the resolution. And we talk about it and hopefully get them to agree on it, and then carry on with the board. So a long story.
I've had so many questions. So let me go to, first of all, to Gary Parker. If removing a director is the board's choice and one is removed for disruptive behavior, what happens if the removed director has valid opinions? So in other words, the chair is actually using their power okay, maybe that's the first question. Is it the chair that decides, or is it the board that decides?
It becomes an item in the next board meeting. It's the whole board. The
Okay.
board has the power to dismiss, not the chair. The chair calls at the next meeting, you have agenda item, removal from the board of the Brown. And it's
so the chair can't hold a power over the directors and then force the directors to do what the chair wants. And then I guess the second part of Gary's question then is about the what happens if that director really did have valid opinions and now they've been removed?
You mean it turns out that the resolution,
in hindsight,
and with hindsight, he had a point. But I think then it has to be absolutely, I would acknowledge it as the chair and say to Peter Brown, whatever his name is, Peter, you did have a point in this, and it's a pity that we couldn't see eye to eye on this issue. But my conciliation was to try and get the resolution between you and and Jack. I mean, you couldn't have you and Jack arguing across the table all the time. But it's a valid point, and I'm going to raise that at the next AGM, that actually you did make a valid point. And I'm certainly going to discuss the next board meeting, and we'll take it into consideration. So take it under consideration. So, but certainly you don't, MI doesn't give the chairman the power to do it. The board has the power to do it.
Mm. I have had the misfortune of being in meetings where a chair, not a chair, a director, I was a fellow director, completely, well, actually I was an observer of the board, and a director completely lost it and just started banging his head on the table. And completely, yes, unbelievable. So it wasn't, so you could have a look at my CV. It wasn't one of the boards that I mentioned on my CV. But what do you do in a case like that? As a fellow director, I just look at this, and it was, you'd never think that that kind of behavior happens in a boardroom.
Well, of course, the chair has to take control of a situation like that. And I'll never forget when I was asked, when APSA, if you remember, APSA sold interest in Barclays. And
Yes.
Barclays sent out a whole legal team, I mean, and the arrangement of the rearrangement of the shareholding was a document as thick as this rearrangement process. And they asked me to chair the meeting. And about, I would say about 200 people turned up shareholders. And the meeting started like this. I welcomed everybody to the meeting. And I said, I've been appointed by the High Court in Witwatersrand to chair this meeting. It's a rearrangement of shareholding will result in APSA acquiring all the interests of Barclays here in South Africa, and Barclays will leave South Africa. This is a public company, but it's a private meeting. You'll see there are people at the door in black suits. Those are my security people. Anybody who misbehaves, I will ask them to have you removed. Because this is the same as if I invited you to my house. If you don't behave, I would ask you to leave. I expect everybody to behave and ask their questions in a proper manner, and let's deal with this matter, which is it's a large matter, and let's deal with it sensibly. If anybody starts with any trouble and there's anything, I will exercise the powers vested in me as chair. Right, item number 1. Any questions? No questions? Right. Item number 2. Anyway, we went through 5 items, no questions. And I said, well, then the rearrangement is carried, and it took about 10, 15 minutes. We went outside, and the chaps from Barclays said, I've never seen anything like that in my life. He said, we came here, we've got 3 lawyers, and we went about all this and everything. I said, you know, people don't realize the power. It's a private meeting. It's not a public meeting. It's actually a private meeting. And I'm the person, the court has vested in me the powers to control that meeting, to make sure everybody behaves. And they deal with the questions in a gentlemanly manner. And all I did was tell them that's what I expect of them. And if nobody did it, I would have them removed from the meeting. And I pointed to the people who would remove them. That's all I did. And but that is the power of the chair. And very few chairmen actually realize it. So your man knocking his head on the desk, I would have said, leave the meeting. If not, I would let people remove him.
And what happens if you get collusion? If you're a director and actually the chair is biased, what can you do as a director when that happens? Do you remove yourself?
Yeah, Kerry, you've often heard me say the greatest attribute of the non-executive director is courage. You've got to have courage. And there's a lot of C's: courage, compassion, and other things. They're all C's, But courage is perhaps the most important thing. And it takes some courage for Carolynn to say, Chair, with respect, what you've just said shows bias. What you're saying is X, Y, and Z, and you should do this impartially. So let's just try and deal with this impartially. And the point being made by X, if we can just rediscuss it, Chair. Thank you.
Brilliant.
You have to.
Yeah. You call it out and you bring transparency into the room. Yeah. So that was actually a question that came from Berenice, who asked, what if the chair is biased? So I think that's great advice. You know, if you are in the boardroom and you see a chair is biased, you actually have to call it out. You have to be transparent. And in the Good Governance Academy, we have a new initiative called Women on Boards. And recently we had Happy Masondo, who was a director on the SAA board when Dudu Mnyeni was the chair. And she also explained conflict of interest. And she also emphasized that point about have to have transparency in the room. We've got one from Paco here. I experienced a situation when the chair abandoned the meeting to take an offense of being asked questions by one member before even the meeting had started. Everyone followed the chair, and I stopped them to suggest that we had to appoint an interim chair to continue with the meeting. Fortunately, my suggestion was agreed and the meeting was successfully held. Any comments?
Well, I think that chair shouldn't continue as chair, obviously, but you should have a lead independent non-executive director. And that lead independent non-executive director is there exactly for that situation. Something like that happens, he or she takes over. Or the chair says, I've got a conflict here, I'm recusing myself, he takes over. So there's a purpose in appointing independent non-executive directors, but you always have a lead independent non-executive director where you can discuss matters where the chair is conflicted or the chair says to hell with all of you and just walks out of the room.
Yeah. There's one from Yusuf here. I'm not sure I understand it, but let me read it. How does a chair deal with partiality amongst the board of directors when a difference in direction by the chair is a disagreement to others? So the chair has a different opinion.
That is going to be dictated by the offline discussion, which I believe is absolutely critical, that you have all these discussions offline so that when you make that business judgment call, it's a collective mind, make it, and it has to be unified. And going offline is to get it unified. What are the value drivers for this business? And I always think the best example was FedEx, that made the accuracy of their responsibility of their delivery of documents and the absolute value driver of the business. If we don't do this responsibly and reliably, we're not going to have a business. So you ask yourself everything, is this reliable? Will it be seen to be reliable? And it becomes the very purpose of the business to let the external stakeholders look in and say, they're so reliable in delivering documents. And they were. As you know, FedEx built its own fleet of aircraft eventually. So, and it was
amazing.
On just agreeing that value driver.
And it's outside, it's preparation. Okay, so there's a lot more to a board than just opening your pack and reading your pack and arriving.
Very much so. And I'm old enough to remember the days when people used to arrive at a board meeting with a pack still in the envelope and slit it open. At the board meeting. I called them the gin and tonic brigade. You know, they arrived for the lunch and the gin and tonic. Anyway, that doesn't happen anymore, thank heavens. But,
well, we hope not. There's a follow-up question here from Gary. It's about, he's following up on the remove director And then there's a SENS announcement that says, or a stock exchange announcement notice that says resigned to follow other opportunities. So there's not a lot of transparency when a director is removed. And he's saying no real information is given to stakeholders and, more importantly, to shareholders. And what's your view on that? Should it be transparent why a director was removed?
Absolutely, it should be transparent. I agree with Gary completely. Should say that there was a dispute and the board had a meeting, and in terms of section so-and-so of the memorandum of incorporation, the board agreed to remove him.
Mm. And it should be transparent. So the true reason.
To say that he resigned paints a completely different picture of what actually happened, because he didn't resign. He was made to leave.
And wasn't left to pursue other opportunities. Well, actually was made to leave.
Absolutely.
Thank you. And here's one from Edmund. Thank you for the informative session. Can you expand on the role of the lead independent director on the board and the relationship with the chair and the board, especially in the event of discordance?
Well,
you mentioned a little bit about it, but
yeah, if the chair for any reason can't carry on through conflict or whatever happens, or he feels there's a bias arising in his own mind because of something that's happened, well, then he should recuse himself, and the lead independent director should take over. And that's why of the independent non-executive directors, you appoint your lead independent. He's there to take over when the chair just cannot continue for whatever reason.
Thank you. Haley asks a very interesting question now. This is about the outer board work. Is there not a risk that the offline discussions will result in a groupthink or, I guess, lobbying? May also prevent from robust discussions taking place in the actual board meeting. Yes, offline discussions may become lobbying.
No, what you're doing is deciding the mental tools on which you're going to actually discuss an issue. So you agree the purpose of the company. If you don't have purpose of the company agreed, well, then you haven't got a unified collective mind. I mean, you think you want purpose, I'm thinking another purpose. And that doesn't give quality decisions. So that board's got to agree on the purpose. That's got to be one mind on the purpose. You've got to agree on the risk indicators, the great risk indicators. Now, it's starting to fascinate me genuinely. I've been asked by a country, which I won't mention the country, but I'm flying to London next week again. And then I'm coming back and I'm flying out again to this other country that for many reasons has become very central in all this geopolitical disruption that we're having on planet Earth. And one of the things they want to discuss with me is whether the companies in that country should have a permanent agenda item, geopolitical issues, because it's affecting the country so much, what's happening geopolitically, that you have a company that's got a holdco there and operating 10 subsidiaries in 10 different jurisdictions. One of the things that it will happen, and which is bugging me at the moment, is that you're going to have different standards of sustainability reporting, for example. Now, already there's compliance panic about sustainability reporting because people don't know what data points do I need, or how do I source what I do, and which standard is my regulator going to choose. And so there is compliance panic going on out there at the moment. And so add to that, if you want a bit of spice, add to that geopolitical disruption, and you've got problems there in the boardroom because your supply in another jurisdiction has to, let's say in the next 2 years, comply with a standard different from the standard that you've got as a whole co. And but you've got to line these things up for consolidation purposes up at the top. And it's going to be absolutely, well, you've heard me say this before, Carrie, it's an eaten mess at the moment, because it's like mixed rifle. I mean, you've got India's now told everybody to go to blazes, and they've developed their own standards.
Yes.
You've got the Chinese developing standards. You've got, and that's must be what, 1/3 of the world's population, China and India together.
Yeah.
Then you've got the EU just on their omnibus project, diluting their double materiality standards because it was too voluminous. You've got the ISSB still developing standards. The next standard is on nature and biodiversity. You've got people choosing different audiences.
Mm-hmm.
And you've got people thinking, well, if they tick the boxes of the standards of the ISSB, for example, then they've discharged their duty of accountability. Well, it's not so. Because by definition, the general legal definition is anything which is material, meaning that it's a matter which could influence the mind of the user, whether he or she will continue granting credit to the company or not, for example, should be disclosed. And if you don't disclose it, it's a criminal offense. And of course, you could also be liable in damages to the company.
Mm-hmm.
So it's interesting that some companies have got this sort of thinking that, well, the ISSB follow those standards, and now we're going to follow the ISSB standards. So we must get this ready to get our data points going, et cetera, and we follow those standards. End of story. It's not the end of the story. And they've got the principle of interoperability, which, as you and I have discussed, you more informed than I am, that it's actually an IT term where the two systems can't speak to each other. So you actually develop words so they can speak to each other. So interoperability has now been introduced into sustainability issues, so that if there is something which you think is material, well, then you don't take a GRI standard and stick it in, to deal with it, because the outcome is adverse to the environment, and it's not financial, which is their audience. So it's becoming a real eaten mess, and people have gone into compliance panic mode.
Can I try and understand this? So it's the board of the multinational, and you're trying to consolidate your sustainability reporting, and you've got perhaps you've got, executives or even directors from different jurisdictions. You've got these companies reporting up with what's material according to their standards of compliance. So they're disclosing, and now you're having this debate in your boardroom, and you've got different perspectives, and those perspectives because of the jurisdictions are actually in discord. And now this holding company is having to report on what's material in their eyes to what's sitting in all of these subsidiaries.
Their regulator. The only thing they can do.
And their regulator.
So the only thing they can do is follow what their regulator has regulated, they have to do, and add the things that as additional information in their accountability.
So actually the
board,
board,
they can do.
Yeah.
That's why I've been talking to, I regard as the three major, at the moment, the SEC still has to stop with its directors and start drawing standards. But at the moment, the CSRD, the ISSB, and the GRI are the three major standard setters for sustainability. And I'm trying desperately to get them to align, to talk to each other and try and align it. Because if we get alignment, it's one step further to getting a global comprehensive corporate reporting system, which would make things easier for comparability in mergers and acquisitions, and of course make decisions more expeditious in the capital markets of the world. So it really would be a positive thing. And if I can get that right, I should get another Lifetime Achievement Award.
It will maybe take another lifetime to do that.
They can
But we
actually
can only
write them.
start.
I've been trying for the last 3 years. I have got them talking to each other, but
To get some kind of answer. So getting back to the discord in the boardroom, so that isn't a discord, actually. There needs to be, even though they probably will be arguing their perspectives from their regulatory perspectives, we're going to have to, before you even go into that discussion, there's unity in terms of the priorities, as you say, the purpose of sustainability reporting for that organization and that jurisdiction, so that you as directors can discharge your duty. And that becomes almost the business of governing rather than governing the business, because the business has its sustainability report. Now you're actually talking about the business of governing. How much time do you find is actually spent in a board on issues like this, where you're actually talking about the business of governing? I mean, dealing with discord is the business of governing too. How much time
what
generally?
is going to happen, Kerry? You're going to spend more and more time on that because of the lack of the standard setters to actually come into alignment. So it's very interesting. It was interesting for me last night in London. That was it last night? No,
The night before.
not
Mm-hmm.
before. The big three standard setters were all present at this award ceremony. And I spoke to all three of them, grabbed the opportunity. And the one of them said, and I won't say who it was, said, the trouble is that our foundations are different. Our foundation is the activities of the company and how that impacts on the three pillars for sustainable development: the economy, society, and the environment. The other one looks at the economy, society, and environment and how it impacts from the outside onto the value of the company. They said, how can we get those foundations together? Well, just agree, which I think is correct, that sustainability, like a coin, has two sides. It's both inside out and it's outside in. It's just a reality. And once you accept that, the two of you can work together. And, anyway, we had an interesting discussion. But then something else, we moved on. But I think that is the answer.
Yeah.
You've just got to accept that it's like a coin. It does have two sides. And it was very interesting when SASB was formed. I was the chair of the GRI at the time. And Jean Rogers was at the GRI, and she wanted to start this at the GRI. And she and the then chief executive, Ernst, who unfortunately died of an aneurysm a year later, so just couldn't see eye to eye. And she left, went back to America, and we're in San Francisco. She started SASB.
Mm-hmm.
And SASB, as you know, has got then did standards for 77 different industries. So it's industry specific. That's the first thing. The second thing is it focuses on the three pillars of sustainable development and how that impacts on value creation, enterprise value, as they call it for the company.
Mm-hmm.
And as if
Now,
nothing happens, there's no impact on those three pillars from the activities of the company. But of course there are. And
now
so
you would,
URI
sorry.
and the ISSB remain divorced. And really they should get married.
You were chairing that board then, right? When there was discord essentially between Jean Rogers and the rest of where things needed, well, they wanted things to go to. Now, is that a management issue because she was at a management level? Do you leave that to the CEO, or does the board actually get involved in that kind of significant move?
Was the chief executive. And this came to
Sorry, who was?
Ernst was the chief
Oh,
executive.
yes. Mm-hmm.
Jean was one of the senior managers and was on the board. No, I can't remember if she was on the board. Anyway, she was a senior manager there, and she had this idea. And I thought it was really worthy of consideration. But she resigned and went back to America and started. So it really never got to a board discussion, which is a pity. Maybe could have resolved it there and then. But
talking about
think that there should be a merger between, or FRS should acquire GRI.
Try and bring alignment. On that question about Jean and the executive level, so this question from Matembo is asking, should a director who is being considered for removal to be removed at the next agenda item, should they be informed of that? First of all, should they be involved? Should they be informed of the discussion? Should they be in the room? And then how are they informed of the decision after the fact? And can removal be done without having a board meeting at all?
No, because the MOI says the board must remove. The board has to
Right.
about. But obviously, the person that may be removed has notice of what's happening, because if the chairman doesn't speak to him, which I think the chair should, he's going to get the pack anyway. And the pack has an agenda item removing Peter from the board.
So they get the pack.
And they'll have reasons why they want to remove him from the board, so they would get the pack. This is then discussed, but then he is excused from the meeting, obviously, and the rest of the
conflict of interest.
The rest of the board discusses and comes to a conclusion to remove him or not remove him.
Okay. All right. So it's following the general process as you would for any other conflict situation.
Correct.
Mbali Mjeni says, in your experience as chair, how have you dealt with the issue where two executives present conflicting information in a meeting? Now, I think from the board agenda discussion webinar, we had a little bit of that discussion.
Well, if it's conflicting information, it may warrant that the meeting is adjourned. It may be so critical. If it's not that critical, you certainly, it must be discussed at the next meeting. And there must be some research done on it, and you get the management to report on this issue. And you have to discuss the next meeting. But obviously, if it's informative and it's pertinent to the business of the company, then you must discuss it.
In the case of in an audit committee, now an audit committee is quite independent, tries to operate independently from the board. When there's dysfunction that happens in the audit committee, what is the chair of the board's role and extent of influence over an audit committee?
Well, the chair of the board has no control over the audit committee. He, of course, can attend the meeting as an observer, but you should have an independent chair, which is usually one of the independent non-executive directors becomes the chair of your audit committee. So the chair of the board just cannot sit and overrule the chair of the audit committee at that meeting. But if something comes up there which is really critical, then in the audit committee report, I would imagine that critical thing would be reported and it would come up to the board for discussion, contained in the audit committee report.
If you're sitting as the board chair on that audit committee and you see dysfunction happening, you can't really say anything in that meeting, can you?
You can. You can try and resolve it, but if you can't, you must put it in your report and it comes up to the board.
And the audit committee report. So the chair, basically, would you ever take the audit committee chair aside and provide them with some guidance?
I would say it's depending on what that issue is. I wouldn't like to influence, what the board is going to decide once they've got the whole report and the story of this information.
And what happens if you have a discord happening in a committee meeting, and what gets reported to the board is not actually what happened in that committee, in the committee meeting where the discord happened?
Then you're a very naughty subcommittee.
Right.
You haven't reported what's actually happened. I mean, something which is discordant, you should absolutely report up that there are two views on this issue, and they're clashing. So you should report that so that the board is absolutely informed, and then the board can think about it. But you can't just keep quiet about it.
And if the chair knows that that happened and the committee has been naughty, how does that get resolved?
Well, I think the chair of the audit committee is actually, that's a form of intellectual dishonesty. You think about it, and I think it's a matter for serious discussion by the chair of the board and the whole board as to whether maybe we change the chair of the audit committee, because that's really intellectual dishonesty not to give both sides of the story, just one side of the story.
Absolutely. And this is where bias creeps in as well, is it? And courage, as you say, to actually call it and to be transparent.
Absolutely.
Let me find another one here. Okay, well, this one is a bit like that transparency of the resignation. So here it says, should there be transparency? Moketsi says, should there be transparency where an NED resigns due to persistent chairperson's bias? So we can think of examples in well, public and private entities where the chair is clearly perhaps conflicted, and then an NED or more than one NED resigns. And should there be transparency in terms of why they resigned?
Well, that shows courage on behalf of the NED. Let me just say that it happens mostly in our companies that are state-owned, because the companies usually created not in terms of the Companies Act, but by statute, becomes a company and becomes an entity in law person. And usually they have a term in that statute which says that the government as the sole shareholder, will nominate the chair and the CEO. Now, that you join that board as a director with something just waiting to happen to knock you on the head. Something's going to happen because the chair comes into the boardroom absolutely with two pips on his shoulder, and those pips are clashing. Comes in as sole shareholder and leader of the board. Well, you can fight the chair, but you can't fight the whole board. You can't fight the shareholder, because the shareholder on the architecture appoints the board. So, so there's conflict immediately. Then the shareholder also has the power to appoint the chief executive. The chief executive, the appointment of the chief executive is one of the most important decisions the board has to make. Why? Because he leads the team who's carrying out and executing the decisions of the board. And if he messes that up and something goes wrong, who gets blamed? The directors.
Yeah.
And you haven't even appointed him. So it's a complete
undermining of.
It's a misalignment completely. And you start off, and this is what infuriates me about entities in the state, that they start off badly governed.
Just by their constitution.
You just cannot get it right that the shareholder appoints the chairman and the chief executive. It's patently incorrect. You're mixing authority with responsibility. That's what you're doing.
Yes, absolutely. And as you say, specifically in controlled entities. I know we've got 10 minutes left and there's lots of questions still, but I just want to ask one specifically, because as you're talking now, there's a knife edge, and we mentioned it a little bit last time around the strategic transformation, is when a chair, it's facilitating versus leading versus being the head of, as a chair's role. So you're saying, on conciliation, you're putting forward a position, trying to solve the problem. You are being transparent and identifying things. There's a lot of leadership that a chair is providing, a lot of research, formulating how the board should operate, working through you, and in terms of the discussions. What is that fine line between being the head of the board, as in the board defers to the chair, especially when the chair is given the casting vote, and actually leading and facilitating the board? How would you guide us in terms of that real knife edge?
One of the most important things of the chair is to be a good listener. He or she should be the last person to speak on an issue, because when he speaks on an issue, he's got authority, and it colors the thinking of everybody around the table. So he or she should be the last person to speak. But gathering all the information and make sure you squeeze the lemon absolutely, there's no juice left in the board. Then you can express a view. But until then, you don't express a view. You keep it to yourself, because it does color the thinking then of the board.
Yes.
And so the important thing is to be a good listener. I mean, it's one of the critical things of a board. The other critical thing of a chairman is to be a bit arm's length with his directors, although he's got to be collegiate. And I experienced that when I was a director of First National Bank and chairman of the Corporate and Merchant Bank, when a senior executive had been a bit naughty, and the board decided that I should have the meeting with him and decide what to do. His wife and my wife were friends, and they played bridge, and I'd been to his house for dinner, he'd been to my house for dinner, and it was one of the most painful things I had to do in my life. And what did I learn? As the chair, you collegiate, because you're part of the directorate, but you've got to be a bit arm's length at the same time. Very difficult. That's what you've got to do. So it came a time in my life when I decided to resign as a director of every company that I was involved in. I became a patron of things, but not a director, because I just didn't want to color people's thinking. But as a patron, I try and fulfill the role.
Yes, of course, because your eminence comes through, and if you're chairing a board, nobody would say anything, even more so than just being a chair. That's okay. I understand now why you haven't taken up directorship positions, even in the GGA. You're a patron and not a director. I better understand now because of the influence. Yeah. You said you let the conversations carry on and then you listen. One of the things that I've seen boards battling with is that how long can those conversations, how long can the discord or dialogue happen to create a unified position? How long do you let it go on for? And can you extend the end of the board meeting as a result of the need to discuss?
One of the critical things the chair's got to do is make sure that management is reporting clear, concise, and in an understandable manner. I have sent many management reports back and said, just redo this in the pack. Just redo this. It's incomprehensible. And you've used jargon, which you use every day. But I don't want a list of translations of the jargon. Do it in clear, concise, and understandable language. Now, what I do that so that people can read it and actually understand it, and hopefully make then a contribution to the business judgment call which the board is going to make. But if you don't do that as chair, that's when you start getting the long discussions, because the report from the management is not clear. And you start getting these long discussions going on. But what about this? What about that? And you haven't cleared it up before. So as chair, I've always become like the editor of the pack. I will make sure that completely understandable. And I want to make sure that that they can. And then I test, of course, their diligence, that they've done their homework to explain why they made the decision. And that's when I really get charge of the board. But I think it's very important for a chair to make sure that the pack is clear, concise, and understandable. Very important for the chair to speak to the chief executive, maybe the financial officer, or certainly the company secretary about certain things before the board meeting. To say, what are you trying to achieve? What is this? So
And how? Sorry.
So you just shorten the meeting. But if you don't do that, you just jabber on about actually trying to define things at the board meeting, and that really is wasting time. I think board meetings should be no more than 3 to 5 hours. If it takes longer than that, to resign. What does it mean? It means that the board just hasn't been functioning properly. That management is just not reporting in a clear, concise, and understandable manner. That board members just haven't been understanding what's going on around it. And you then have got a board that's got big problems, and they would have made business judgment calls which are not properly informed. So that's why you become a member of a board and there's such liable that something goes wrong, and it will go wrong on that basis. And
yes.
That's why if it goes into the second day, resign.
Because it's not happening. It's just not happening.
It shouldn't.
And how prescriptive can the board be in asking management for information?
Very prescriptive, but again, not something which is irrelevant to the issue that you're going to decide. And the chair's got to constantly keep in mind the business judgment rule, Carrie, that because that's what's protecting his directors in the business judgment rule. That he's got to make sure that as much as possible, objectively, they've got all the facts. So certainly, companies that I've chaired, I ask them to sign a document they've got no reason to believe there's anything in conflict with that's on the agenda. And thirdly, to make sure the decisions you make are rational business decisions at that time in those circumstances. Now, it's very interesting that I think today you should ask the question also to ChatGPT research and get an answer, because 4 years down the line, it's going to be even more sophisticated. And they will go to ChatGPT and say, did you think about this question or that question? So I think every board today should go to ChatGPT research and put the issue to them and give as much context and detail as possible, and wait for 25, 30 minutes and you get an answer. And there may well be something there that you haven't thought about. And because you can take poison of it if that decision you've made turns out to be harmful to the company 4 years down the line. The directors then will go to ChatGPT and ask that question and say, but did you consider this at the time, Mr. King? No, we didn't.
Because everybody's got a reference library at the fingertips nowadays.
Absolutely, absolutely.
So you should be able to get that information. It should be available to you, and then obviously apply your mind on top of that information, because it could be these,
I'll give you a great illustration of that. Happened to me the night before last night at the award ceremony when I was awarded this Lifetime Achievement Award. They said they've got 10-minute video about my life they're going to show. So I thought, haven't spoken to anybody about it. But they took the book written by David Williams, the Corporate Revolutionary, fed it into ChatGPT, took out the highlights, and got pictures of me at various times, and did a 15-minute video about my life. Quite extraordinary. Quite extraordinary.
Fantastic.
Yeah.
Well, if we can get our hands on that, I will put it on the GDA website, because that would be fantastic. It would really be lovely. And we can add all the summaries of your corporate revolutionary webinars that we've hosted as well. Add that in. So that sounds brilliant. But we have run out of time. Again, thank you so, so much. It's been wonderful having this discussion. And thank you to everyone for joining us online today. We've had just over 200 odd people participating. It's been lovely watching and seeing your questions. Really enjoyed your questions. And thank you for your chats and the discussions on the chat function. Our next discussion, Taking the Helm with Professor King, will be held next month. So please watch out for our emails, subscribe to our YouTube channel, listen to the summaries on our Spotify channel, Spotify show, I think they call it, and yeah, join the mailing list so that you can keep in touch. Professor King, thank you so much. Thank you again. And literally you landed and joined the webinar. So I really appreciate it. Thank you.
Thank you very much. Bye.
Bye.